Soon after the invention of the printing press, English and continental monarchs, fearful of the power implicit in its use and the threat to establishment thought and order, political and religious, devised restraints such as licensing, censors, indices of prohibited books, and prosecutions for seditious libel, which generally were unknown in the pre-printing stress era. Official restrictions were the official response to the new disquieting idea that this invention would provide a means for mass communication. And that again is from Bellotti, Berger's Concurrence. It may well be that we have erred in dividing the speech and press clauses. In the First Amendment, it reads like one clause: the freedom of speech or of the press, freedom of speech or of the press. When we read this complete clause as protecting the individual right to disseminate ideas to the public, it makes sense that the framers would have included the complementary concepts of speaking and writing. It's unlikely that the public in 1791 understood the freedom of the press in the broad way we understand it today, and therefore it would have been perfectly sensible to explicitly protect both spoken and written expression in the First Amendment. In fact, of speech and press, the founding generation more often emphasized the freedom of the press than the freedom of speech. This is reversed today. A recent poll found that 47% of Americans named freedom of speech as their most important freedom. 1% named freedom of the press. Only 14% of Americans could even name freedom of the press as a freedom protected by the First Amendment. But to a founding generation troubled by British regulation of the use of the printing press, the liberty of the press was conspicuously important. It was through the use of the press that Protestants spread the Reformation to change the face of religion in Europe. It was the printing press that enabled Thomas Paine to reach a vast portion of the Americans living at the time with his earlier cited pamphlet decrying British rule. It was with the press, with presses, that the Federalists and Anti-Federalists conducted a widely followed debate on the merits of the new Constitution. In Federalist number 84, Hamilton responds to the Anti-Federalist objection to the lack of a Bill of Rights in the Constitution, and in so doing, he discussed only one specific liberty, suggesting the importance of that liberty, and that one liberty was, you guessed it, freedom of the press. Likewise, in 1774, Congress sent a letter to the inhabitants of Quebec, Continental Congress, sent a letter to the inhabitants of Quebec attempting to enlist their support against the British. This was a year before we took a slight change in strategy and just invaded Canada. The letter lauded various rights enjoyed by Americans. It contained no mention of the freedom of speech, but it had quite a bit to say about the freedom of the press. The last right we shall mention in regards to freedom of the press. The importance of this consists, besides the advancement of truth, science, morality, and arts in general, its diffusion of liberal sentiments on the administration of government, its ready communication of thoughts between subjects, and its consequential promotion of union among them, whereby oppressive officers are shamed or intimidated into more honorable and just modes of conducting affairs. That's from Appeal to the Inhabitants of Quebec from the Journals of the Continental Congress. Given the importance of the press at the time, it's no surprise to find written expression explicitly protected in the First Amendment. Further, the content of the Appeal to the Inhabitants of Quebec illustrates once more the extension of the protection of the freedom of press, not to a professional reporter class, but to all who communicate through that technology. We might perhaps think of the professional journalist as advancing truth, but the advancement of science, morality, and arts in general suggests the products of a much larger body of communicators. Thus, it should be apparent that the freedom of the press protects not only newspaper personnel, but scientists, moralists, and all engaged in all arts. But returning to the superfluity question, it seems most likely that the public would have understood the press to be referring to writings by all citizens, not just to those of an elite group, which frankly did not even exist in 1791. The applicability, and this is my third part then, would be the applicability of the press to modern technologies. Two further questions arise for the originalist who adopts the liberty for all interpretation of the press. First, does the freedom of press protect only the actual production of written material? And second, if the press refers to the printing press, does the freedom of the press also protect blogs and televisions and other forms of communication that do not originate from a printing press? Well, the answer to the first question is surely no. The Supreme Court has consistently held that the freedom of the press protects more than the mere writing of a material. Liberty of circulation is as essential to the freedom of the press as liberty of publishing. Indeed, without circulation, the publication would be of little value. That's Ex parte Jackson from 1877. As the court has further explained, the freedom of the press would be meaningless without the included rights to write, publish, and circulate. Thus, Justice Scalia wrote in McConnell versus FEC, licensed printers, and it matters little whether authors are still free to write. Restrict the sale of books, and it matters little who prints them. What good is the right to print books without a right to buy books from authors, or the right to publish newspapers without the right to pay the deliverer? However, the breadth of activity protected by the freedom of the press created in the First Amendment does not suggest that that freedom affords special protection to a universe of acts by members of the professional media which would not be protected if engaged in by others. It is the excessive claims of such protection that first brought this subject to the front of my mind. It has become commonplace for members of the professional media to suppose that their special freedom enjoyed as members of the press includes freedom from obligation to answer subpoenas, testify in court, or put up with all sorts of things that common people must endure. A few years ago in Washington, D.C., a special prosecutor was leading a grand jury investigation of the suspected unlawful disclosure of the identity of a covert CIA agent by high government officials. As part of the investigation, the grand jury issued subpoenas to a New York Times reporter named Judith Miller, along with a correspondent for Time magazine and the corporate entity producing Time. See Henry Grand Jury Subpoena Judith Miller, 438 F. 3rd. It was undisputed that Miller had obtained information concerning the identity of a high government official who had leaked the name of a CIA agent. Miller, however, refused to provide her evidence to the grand jury, claiming that her information had come from a confidential informant and arguing that the First Amendment freedom of the press created a privilege for reporters to maintain the confidentiality of their sources. A unanimous panel of the D.C. Circuit, consisting of Judges Sentelle, Henderson, and Cato, rejected the proposition that the concept of freedom of the press contemplates protection beyond those applications properly classified as the preparation and circulation of publication. I stand by that today. Not only did neither Miller nor anyone in her support ever come up with any historic evidence that the concept of the free press at the time of the framing, or for that matter long after, included a broad protection of activities that would be unprotected if conducted by anyone other than a professional journalist. But as we noted in the Miller case, the question was definitively answered by the Supreme Court in Branzburg versus Hayes. In Branzburg, as in Miller, a journalist who conceitedly had knowledge of criminal activity resisted a subpoena under the claim that the First Amendment provided protection to a journalist against the revelation of his sources. As we later echoed in Miller, the Supreme Court held that there is no such protection within the concept of First Amendment freedom of the press. Justice White, writing for the court, declared that it is clear that the First Amendment does not invalidate every incidental burdening of the press that may result from the enforcement of civil or criminal statutes of general applicability. Under prior cases, however, valid law serving substantial public interest may be enforced against the press as against others, despite the possible burden that may be imposed. Justice White went on to drive the point home. The court has emphasized that the publisher of a newspaper has no special immunity from the application of general law. He has no special privilege to invade the rights and liberties of others. And I cannot leave the discussion of Branzburg without recalling one other pithy quotation from Justice White's opinion for the majority. We cannot seriously entertain the notion that the First Amendment protects a newsman's agreement to conceal the criminal conduct of his source or evidence thereof on the theory that it is better to write about crime than to do something about it.